Hello everyone, I am Sakshi, and today I want to ask you a question that rattled both the legal community and the public. If a man grabs a child, tears her clothes, and tries to drag her into hiding, has he attempted rape? In March 2025, the Allahabad High Court said no. It called it preparation, not an attempt. Within days, the Supreme Court stepped in, taking suo moto notice. But this was not just a fight over definitions, it struck at the heart of something bigger. How far does someone need to go before we call it an attempt to rape? To understand this legal tug of war, we first need to grasp the basics. How are sexual offenses defined under Indian law? So let's start with the Indian Penal Code or IPC. Rape under Section 375 of the IPC is defined as an unlawful sexual activity carried out without consent. The definition covers a range of acts involving non consensual penetration, and the law makes it clear that even minimal, non consensual contact with a sexual nature may be sufficient. Consent here must be free, informed, and voluntary. The law also lists situations wherein consent is not considered valid. For example, when given under pressure, deceit, intoxication, or if the person is under 18 years of age. Now, what about when the act isn't completed? That's where the concept of attempt to rape comes in. IPC does not have a specific section for it. Instead, it falls under Section 511 IPC, the general provision for attempt to commit crimes. This section states that if someone attempts to commit an offense punishable with life imprisonment or a specific term, they can be punished with up to half the penalty of the completed offense. The crucial legal distinction here is between preparation and attempt. Buying a weapon might be preparation for an assault, but actually swinging it is an attempt. In the context of rape, intent alone is not enough. There must be a direct action moving towards the commission of the crime, crossing the line from just planning to actually doing. Like the legal maxim goes, attempt begins where preparation ends. Then we have offenses that fall short of attempted rape but are still serious violations, such as outraging modesty. Section 354 penalizes assault or use of criminal force against a woman with the intent to outrage her modesty. Section 354b specifically deals with assault with intent to disrobe. They carry lesser punishments than rape or attempted rape. So, when does POSCO come into the picture? POSCO comes into the picture when the victim is a minor. A minor is an individual aged below 18 years. POSCO is a general neutral act. Chapter 2 of POSCO addresses sexual offenses against children. POSCO lays out a clear structure covering everything from penetrative and non penetrative assault to sexual harassment, aggravated offenses, and even attempts. It is one of the few laws that spells out protection for children in such detail. With this legal framework in mind, let's look at the case that ignited this controversy. Here are the facts of the case. The complainant and her minor daughter were walking home when two men, Pavan and Akash, offered the child a ride. But instead of taking her home, the accused grabbed her breasts, broke the string of her pajama, and tried to drag her to a culvert. Thankfully, passerbys intervened, forcing the accused to flee, leaving the child physically unharmed beyond the initial assault. When the police did not act, the mother sought justice through courts. Her complaint led to a court ordered police investigation. culminating in a special POSCO court in taking cognizance of this matter. This special court charged Pavan and Akash with attempted rape under IPC Section 376 and Section 18 of POSCO, acknowledging the child's age and nature of the alleged crime. Ashok, Pavan's father, faced charges for allegedly intimidating the mother. In a move that would soon ignite a firestorm, the accused trio challenged these charges in the Allahabad High Court. Their argument? That even if these allegations were true, it did not amount to attempted rape. The Allahabad High Court agreed, ruling that their acts, while deplorable, amounted to preparation, not an actual attempt to rape, since the accused had not gone beyond disrobing and no further acts such as attempted penetration was initiated, the legal threshold for attempt to rape had not been met. As a result, the court dropped the charge of attempt to rape and directed the accused to be tried under lesser offenses. The court's reasoning hinged on a seemingly fine line, the difference between preparation and attempt. This finding sent shockwaves through legal circles and the public at large. The burning question became, when a child is dragged and partially stripped against her will, how much more must happen before it's legally defined as an attempt to rape? Within days, these concerns reached the Apex Court of India. On March 26, 2025, the Supreme Court took suo motu cognizance of the Allahabad High Court's judgment, citing the urgent need to examine its insensitive rationale. To really understand what is happening here, we need to draw a sharp line between IPC and POSCO. IPC is India's General Criminal Code, and it defines rape narrowly as penetration. And if the act is not completed, you have to prove an attempt under section 511, which means showing a clear direct step toward penetration. POSCO, on the other hand, is a special law built to protect children and has a much wider lens than IPC. Under POSCO, section 3 and 4 addresses penetrative sexual assault. Section 7 and 8 criminalize non penetrative acts with sexual intent, like touching, making a child touch the offender, or any physical contact intended to violate. While many think that Allahabad High Court did not apply POSCO correctly and that is the issue, that's not true. When the Allahabad High Court downgraded the charges, it actually applied POSCO correctly, charging the accused under sections 9 and 10 for aggravated sexual assault. So the issue here is not about how POSCO was used. The real question is, was this also an attempt to rape under IPC? Do actions like breaking a child's pajama string, groping, and trying to drag her away amount to an attempt to rape under the IPC? Or do they fall short, legally speaking, as mere preparation? That is the line Supreme Court is now being asked to draw. While Supreme Court was hearing this matter, concerns over judicial sensitivity were amplified by a separate bail order from another Allahabad High Court judge, which included victim blaming remarks in a rape case involving an adult woman. The Supreme Court responded with visible unease, urging judges to avoid such reasoning. To sum it up, this case is more than just about charge framing. It is about legal threshold for attempt to rape and whether our courts are drawing that line too narrowly in cases involving children. Thank you for watching. If you want more such breakdowns that connect law with real world impact, do like, share, and subscribe.